Hello and welcome to another episode of Cooper's Code. This is our occasional episode where we talk about AI. I say occasional because it's typically monthly, and because AI has been moving so fast, we try to get all of the smart minds together to talk about things with Shahrad Milanfar, Marshall Cole, and today we are joined by special guest Spencer Pahlke. Spencer is a partner at Walkup. Spencer also has a niche focus on mock trials with his own podcast and teaching and developing future lawyers. Spencer, since everyone knows a bit about Marshall and Shahrad, do you want to tell us a little bit about your podcast, your focus, so that people understand a little bit more about you as we dive into this episode?
Sure. Plaintiff's trial lawyer at Walkup, have been for 18 years. Love that. But on the side, a very large amount of my time is spent coaching, teaching trial advocacy at the law school level. I co-direct Berkeley Law's trial competition program. And one of the various things I've done in recent years is co-host a podcast on law school trial advocacy called Unscripted Direct with my friend Justin Bernstein. It's a ton of fun, a lot of nerds.
And we have you here, I think we're all nerds if we're going to be on these subjects. We have you here in part because of some work that you've done related to AI and using it in predictive ways with mock trials and other pieces. And so with that kind of as a high level platform, I'd love for you to kind of kick us off in terms of some of the research and other work you've done so that we can digest it and see how it may play out for people.
I mean, of course, I use it in my practice, et cetera, but I wanted to have an opportunity to see how it would be used in a trial advocacy setting. And every year, Berkeley Law, along with Walkup and other sponsors, host the National Flash Trial Competition. Our fourth annual competition was this fall here in San Francisco, and that was like a perfect opportunity to test out AI.
How did you test it?
So we have 10 teams in the competition. I should say that the competition's format it's called flash trials for a reason. So in each round, you get 45 to 60 minutes, depending on if it's a one-on-one or a two-on-two competition, to prepare. So these students go from knowing nothing about the case at minute zero to trying the case 45 or 60 minutes later. Very useful trial training method that we've used at Berkeley for many years, I will say. But presented a special challenge as generative AI became more and more, accessible, available, because we had to think about, well, what's our rule going to be for how we'll use AI in the competition?
And did you come up with a way of handling things?
We did. The question was, on the spectrum, where do we want to be? Outlaw it or let it be used? Because for better or worse, I'm actually quite agnostic about it from like a moralistic perspective, but for better or worse, it's here and it is only going to become a larger part of practice. We decided to not only say you can use AI more or less in any way that you want to prepare, we also teamed up with Eve Legal to give everybody, full enterprise access to the platform, with the condition being that we'd be able to look at how they used it on the back end.
As far as that's concerned, can you give us an insight into, I know there are a variety of products out there and we're not promoting one over another. Eve has not done a product placement. However, if Eve is making a tool available for your trial teams, that's very generous of them. So perhaps you can tell us a little bit about what Eve is relative to other products out there.
Yeah, and candidly, I also don't use Eve in my practice. I use other AI platforms. However, a law school friend of mine is in the higher ups or among the higher ups there, and I reached out to him. It, as I understand it, is an AI platform that is focused on plaintiff side personal injury cases. I used it as part of the competition, and I was impressed with it. But they were a great partner to share for free access to their platform to all these students.
The next question, of course, is what's the back end? Meaning that you partnered with them, but the exchange was that you got to see what was going on in the back end. And this is where I think we might start seeing some of the utility in other pieces.
Yeah. So, I mean, the deal with the law students was like, you can use AI really more or less in any way you want. Can't use it during the trials, but you can use it in prep. But we're going to look at what you did just to get a sense of how you used it, and that kind of thing. And so I do love math, but I am no specialist in math. And so we have some folks helping us crunch the numbers, and it's not completely crunched, but we have some sort of, preliminary insights into how it was used and that kind of thing in the competition.
looking for the big reveal. And what types of insights have you gotten?
I would say in an overarching respect, it was, thank goodness, at least at this juncture, not life altering. Um, I can go through my list of, I guess I've got 5 points here that are, I think, worth talking about. But the most heartening thing was it didn't appreciably change what was being done at the competition as compared to prior years. And that was, again, like I said, heartening because I am agnostic about it. It scares me and it also excites me. Um, but to have the students still do what they're supposed to do, advocate on their own, think on their own, even though they had access to the AI was, I think, a good sign.
I'm bouncing around a little bit here, but going back to Eve for a second, I'm curious, Marshall, Shahrad, um, have either of you played around with that relative to any of the other tools? Any thoughts on that particular product versus other products?
I haven't played with that particular product, but I have seen it demonstrated before, and it does seem to have some great utility in terms of what it can do and the functionality. There are other products that are out there, and even our practice management system, they just released a AI module that they want to integrate. That's a more advanced AI module that they want to integrate into our practice management. So it is something that there's now more competition in the industry. And I think a lot of the lower level companies are getting weeded out. And now there's going to be some companies that are becoming more emergent in terms of their capabilities and their abilities based on the amount of money that they have pumped into them to provide a product that's more in line with what we would need.
And part of the reason I'm taking this tangent is because I know our listeners have kind of a wide variety from highly technical to want to just, tread water and keep up with what's going on. A product like Eve, how does that differ from, say, Westlaw AI or Claude, ChatGPT, Harvey, the kind of the very high end legal piece? Any insight on where this fits in the pantheon of product?
Glad to give you what I understand
Sure.
the main difference to be. I mean, and it's so interesting, Shahrad, like you say, I mean, this is definitely a survival of the fittest sort of space right now, right? I mean, and sadly the fittest is the richest because they have the most wherewithal to stick around, right? So query what that means in a year or 18 months about who's still, once the tide has gone out, who is swimming with what amount of clothing on. But Eve's pitch is it's personal injury focused and by that they mean they have a whole series of playbooks, they call them, sort of pre-designed prompts that are meant to help you throughout a case. And again, I'm not like advocating for them or against. I'm just sort of saying what I learned in working with them. And I was impressed by the playbooks. In fact, we turned them off for purposes of the competition because we didn't want to have an uneven playing field in that respect. So students and coaches couldn't use the playbooks. But I think that's the thing. They've given some thought to what it looks like to run a personal injury case and, created some, I think, playing field leveling opportunities for real lawyers by having like, here are your best prompts, that kind of thing. So that's my understanding of its main difference. Whereas a Harvey Harvey, we do use that at our firm, much more varied and, it's used not just by lawyers. Of course, you could create your own playbooks there too. But it's sort of more generalized, I would say, than what Eve's doing.
I know before we started, Marshall was talking a little bit about how sometimes he'll queue up a Claude window so that live in Depot, as people are throwing things at him, he's able to throw stuff back. I should let you speak to that, Marshall. I'll return to my question for Spencer, but here's a tangent on that piece.
Yeah, and Spencer, listening to you start out, and I'm very curious to see the final results of how the students used AI because they're not. I'll use the word jaded, but it's probably not the right word. But as having been a lawyer for a lot of years, you get to see different things. You've deposed people in real life, right? Like you can see you're not just given a script of here's what it is, and then how do you want to use AI? How are you thinking about using it? And so I'm just really interested to see how creative they are because it's interesting as being a lawyer and that how we use it and in depositions and leading up to depositions, especially with experts. And I probably mentioned it before. I think it's really helpful to help you prepare to depose an expert. I've got a real estate case going on I was talking about, and I was throwing in a bunch of pro formas with respect to various properties and dealing with cap rates and trying to see variances with cap rates. And obviously, if you just plug and play numbers, your cap rate in a real estate transaction can dramatically differ. And I was using Claude with respect to inputting all this data. And it was really, really helpful for me to teach me more about cap rates and rent rolls and how the various documents that I was using and were going to be used in this case were skewed in certain ways, depending on various factors that this expert was using. And so it's going to be really helpful for me, and obviously to be verified with our own expert, but certainly from a cost perspective to enable me to get all of this information and arm me with great questions to ask without having to have consulted an expert right now is great. And certainly when the time comes, I'll loop he or she in and talk about all the things that I've already done and confirm the accuracy or not. But because what I'm doing isn't necessarily, I'm not seeking like answers to these questions. I'm just trying to understand data, that the variances between an 8 cap and a 7 cap, 6 cap property are helpful for me to be able to ask questions for this expert to understand whether they've considered all of these factors. And so this was in the last week and I've loved it. I've spent a lot of time with it, and it's been very helpful for me.
It seems to me that as a consumer who's constantly bombarded with 5 emails a day from different AI vendors and other vendors, we need to be 2 things in our approach: curious and suspicious. Because what I've found is that a lot of times the vendors and specifically their salespeople will tell you very, very lofty things that will not pan out when you're actually using that product. And that's where we have to understand that ultimately these products can help us do great work for our clients, but there is work that we have to put in it initially in order to get those results. And it's not simply, hey, it's a plug and play, jump in and you're done. You have to learn how to use it. And sometimes we have to know which system is the best system to go to for the particular question that we have. And those are important considerations when you're looking at it from a big picture standpoint.
And I think curious suspicion and the overpromising is definitely something to be aware of, and the survival of the fittest. Because we were looking at products a year ago who were promising some pretty amazing things, and some of those people have already been slimmed down. There's one entity in particular I'm thinking of that no longer really even talks about their AI wrap on their product anymore, whereas others have continued to accelerate. So I'm bringing this back to you, Spencer, because part of the reason I did this divergence is it only Eve that the Flash team was able to use, or was it a look, it's just like you're in a courtroom and you have access to whatever tool you need?
It was, and there's some honor code stuff happening here, right? But I mean, the rule was that for using generative AI, it would only be Eve that would be allowed, because we wanted to be able to look at it on the back end, not because it's better or worse. In fact, it's just built on it's using other engines, but we wanted to be able to look at it at the back end. So it was only Eve for the competition.
And I apologize. I wanted to just kind of pack in a few things along the way, and I feel like I interrupted the flow in terms of the learning that you got from it. So I know you had a number of points that you had from the back end of Eve in terms of what they were doing, what the students were doing.
Yes, but I'm just delighting being interviewed by a podcast interviewer, having sat in that chair so many times and thought about the different tangents that are happening and whether you should go down this route or not. It's interesting, but I hope it doesn't say too much about it. I feel your pain.
Perhaps we should have another, like a meta podcast where we do a podcast about podcasting. How's that?
That's a great idea.
Yeah. Back to you, Spencer, in terms of the takeaways.
So first, people did not wholesale tell AI to do all the work for them. Second, teams most often use the tool for brainstorming. Third, almost all, but not all, 9 of 10 teams used AI to some extent. Fourth, there was an inverse correlation between the ratio of unique prompts to follow-ups as it relates to overall success in the tournament. I can explain that more. And then fifth, For what it's worth, the team that won the tournament also had the most sophisticated AI approach.
Okay, can you unpack numbers 4 and 5, since you said in particular with number 4, you could explain that?
Yeah, I guess my point is that looking at people's use of the AI platform, we categorize their prompts in 2 categories. One is it a unique prompt? Is it like a new topic, basically? Or is it a follow-up as part of a prior topic? And the teams that did the best, and again, this is like, very overbroad, and I got to say it's only 23 trials that this happened in, and, it's not overall representative, and I'm not a statistician, and et cetera. But point being, the teams that had a unique prompt and then dug down within that prompt tended to do better than teams that had lots of unique prompts and didn't dig down, which, makes a lot of intuitive sense because it's sort of more scatterbrain, that second approach. It's like this, that, this, that. The first approach, where it's like, here is my unique prompt and then my follow-ups, is much more, in my view, a part of having a plan. Here's how I'm going to use it. Here's what my primary prompt is. And that, again, only by correlation, tended to correlate with more success in the tournament.
What about number 5?
For what it's worth, I say, again, because of the limitations of the amount of data and all that stuff, the team that won spent a considerable amount of time prior to the competition honing a primary prompt. And we've got a bunch of, I should say, flash trial problems are 20 to 30 pages long. Each of them, we've got a whole bunch of them accessible to students to look at what it's like to practice and prepare. They went through a lot of those problems and used the prompt and then changed the prompt, used Eve to improve the prompt. And once they got to the competition, they had their sort of primary prompt. I think they were the only team that had like, here is our prompt. And they used it right away when the problems dropped each time. And again, by correlation, that seemed to have served them well because, they sort of knew what they were asking for. They got it. And, you could certainly tell a story, one that makes sense to me, that having done that, they were ready to jump into the trial, jump into their prep, because they sort of had a second layer of, here's the fact pattern, here's our analyzed understanding of it. Now we can jump off and get our theme and get our theory and all that stuff. So that's number 5 for you.
I recognize that the question I'm asking is more anecdata than data. Any perception on whether the teams that did better with these tools were teams that were more likely to be able to embrace technology, more engineering IP lawyer types versus
That's interesting.
Our, liberal arts types?
That is a fascinating question, which I do not know the answer to. I apologize. I don't know. I don't know what the backgrounds of the students were. Aside from, I do know that, the sort of the primary question about prior experience at the law school trial advocacy level is if they've done it before, for example, in college. And I know that in the final round, all 4 of the competitors had a lot of prior mock trial experience, but I don't know about their engineering IP interests.
And now that prompts me, and this is outside of what you've been doing, also an anecdata question. Have you noticed any trends in the people that because you've been doing this a long time?
Yeah, 18 years. Yeah, ever since I graduated, yeah.
So in terms of the people that you've taught, have you seen any trends with the people that who've been with your teams in terms of where they end up in their careers?
Lots of them end up in, PDs and DAs offices. They want to try cases, so that's a primary outlet for folks. Also, and I do a lot of work with the National Plaintiffs Law Association, plug to them, by the way. There's a huge flood of amazing law students out there who are spurning big law and saying they want to go work with folks like us. So open your doors and open your arms to them because they are amazing and there's incredible energy in it. But in keeping with that, I have certainly seen more of my students going off to the plaintiff side. I'm a huge advocate for that. And so plug for that. So that's a trend. And of course, big law is big law, and it gets ever more eager to recruit. And I don't know if you've noticed, but the recruiting practices have changed dramatically on big law's side. They are now, so we're in the late fall of 2025. If you're a 1L at a law school, they're recruiting you for your 2L summer right now. So not next summer, for your 2L summer, before you've got grades, before you have any idea what you're doing. And in some cases, they're paying very large bonuses for you to accept your 2L summer, which then turns into a job offer after your 3L, after you graduate. And so there is a huge effort on their part to force people to go to big law. And, to me, it tells me that like we're doing something right if it's scary to the other side that more people are going to our side. So
to follow up on that piece, because you wear many hats in terms of the things that you do, I know you're also involved with getting the word out for plaintiffs' lawyers nationally. For those who want to be involved or want a little bit more visibility on that, can you give a shout out or a website or a how do I do what my part in terms of getting the message out in the plaintiffs' world?
Thank you. What a great question. So absolutely. So there is a new organization, it's about 4 years old, called the National Plaintiffs Law Association, and that's their website, nationalplaintiffslawassociation.org. It is law students across the country who have created an umbrella organization over the top of the plaintiffs' law associations that exist at many law schools now. In fact, as of last count, there are 39 active plaintiffs' law associations across the country, with 17 more coming on board here very shortly. So the eagerness is palpable. I just actually spent the last 10 days, actually, I just spent the last 7 days. In 7 days, I went to 8 law schools on the East Coast and talked about what plaintiffs' practice is, talked to 150 students about it. So check out National Plaintiffs Law Association. And honestly, if you're interested in having summer associates or looking for a way to tap into this energy, please email me, spahlke@walkuplawoffice.com. I would love to help open the door to more law students to plaintiff side.
And just to keep unbiased, I think we have to give a plug to the defense side too here. There's just as many organizations and recruiting just as heavily. So you can just go to nevisec-cole.com and find all you need to know.
Enough of that. No, I'm curious.
More. We need more. We need more.
I didn't. Totally, and I didn't mean to paint you with the same brush. I was using the big law brush, and I don't think you're at a
don't sweep me with that brush.
There you go. And my apologies.
With every yin, there's a yang, and if we don't have defense lawyers, then there's no one to play with, right?
Yeah.
But it's interesting. It's a big. I mean, like when I say big law, you know what I'm talking about. We're talking about these AM Law 100 firms and all that
Certainly
stuff.
Not
that's a different animal than the people we're typically fighting with. That kind of thing.
Yeah.
So.
For those who are following along, we'll drop links in the show notes so that people can get these resources without having to pause and scribble stuff down.
I think it's great that law students coming out of law school aren't necessarily just going for the big law jobs and are really understanding that the way to get in the courtroom is honestly on the plaintiff side. I mean, that's where you're most easily going to get trials outside of criminal. And I think it's great. I really do.
Well, and let's be realistic. Nobody decided to go to law school because they said, I want to be corporate counsel for, name whatever company you want to name. They're going to law school because they have a purpose. And I think for a while, that messaging on the plaintiff side has been lost as to why we do what we do. And I think the work that Spencer and the other law students are doing is now bringing it back to the core values that really get us up in the morning and actually get us to do the work that we do.
And plaintiffs lawyers are cool at law schools now. Like we're cool there, like we're not like chasing ambulances. I mean, it's like you get questions about like, I've heard it's not like, aren't you guys all ambulance chasers? It's not like that now. It's like, I've heard, people describe plaintiffs lawyers as ambulance chasers. How do we fight that image? Like, it's like they're on our team.
I think you just put up $100 million verdict and then you're like, man, I think it's a little bit different than I.
I'm seeing a good segue here, Spencer, because one of the things that we rounded with the group just before we started was an article that Shahrad put forward by Nick Schweitzer and Jessica Salerno at Cornell University. If I'm getting it right, you recently had coffee with Nick, and this is an article on the disutility of large language model AI in predicting juror decisions. And so I think this is a good corollary to the information that you just provided us and a launchpad for us to talk a little bit about how people are using focus groups and AI and actually going to verdict to see what's happening there. I don't know what my question is, but that was the segue.
It's a great segue.
Thank you. Actually, well, I will kick it to you, Spencer, since you had an opportunity to sit down with one of the authors of this paper. Any insight from you as how it relates to what you're seeing on the other side with the mock trials?
Well, that's interesting. So I will say, just as to the paper itself, I've not read the paper, but I watched Shahrad and I, as it happens, watched Nick give this presentation not long ago at a conference, and it's completely fascinating because one problem with AI is it's like got this like positive confidence all the time. It just acts right all the time, which is one reason it's so dangerous. And it's so easy to think, well, it's analyzed all the data in the world, and why can't I just describe my focus group and tell it to like give me Mecklenburg County or Alameda County or whatever, and run it with 100 juries, which people do all the time. And it gives you this very clean, bullet pointed, response. Here you go. Here's your answer to your question. And because it's so good at answering other questions, which we can trust its answer to, you worry that it's going to, it's overly we give it too much trust with focus groups. So Nick's paper and Nick's presentation is all about how like he checked. He's like, okay, well, let's look at outcomes as predicted by AI and by the big data focus groups that they do with jury ball. And like, it's stunning to look at some of his graphs. You're like, here's what AI predicted, and like, here's the outcome. And it's like orders of magnitude in each direction, And that was stunning and also very heartwarming to see shortcomings in AI documented so clearly. I'm looking forward to reading the paper, but the presentation was awesome.
One observation I had in response to this paper, and I've shared this in various places. For a while, we used a Monte Carlo simulator to help us get some information and insights on our case projections. So when we take a case in early on, we rate what the case is worth and we try to be conservative. Similarly, we rate how long do we think it's going to take us to get to conclusion, and we try to be conservative. And what I found when a finance person used a Monte Carlo simulator, which was, we'll have this thing run multiple times and use past data, et cetera, complicated stuff that is beyond me, quite honestly. What we found is very similar to this article, which is no data combustor is as good as the gut instinct of, say, a Marshall or a Shahrad or a Spencer or a me, who's done this for many, many years and has kind of that limbic system sense of, a collarbone fracture from a right hook in Alameda County, non-surgical, that's going to be 175 to 250. And it'll take, 18 months. For me, it's a reaffirmation that there's a human element that will continue in our work. Shahrad.
Well, I mean, let's be realistic. There's a reason it's called artificial intelligence, because there is no human aspect to it. Everything that it tries to do is basically a simulation, and it's a word predictor. It is not a human predictor. And as good as all of us may be in valuing our cases, you still think about, if you have a group of 12 jurors sitting in a trial, we switch out some of those jurors, the result could be different, which is why we all want a bit more certainty. And I think the point of this paper is that artificial intelligence doesn't provide you certainty, but having more of a statistical sampling of human beings will provide you a more accurate understanding of what 12 people may do in a jury setting. And even with that, as close to accurate as it is, I think their documents showed that they routinely underestimate, not overestimate, their verdicts by 20%. And there was one example that they estimated that the verdict was going to be $133 million, and it actually turned out to be a $145 million verdict.
Yeah, I think it's like, when I looked at it, if someone's going to do this and really they do it for trial, it's almost like putting in the prompt, how do I win? At this point, because, in the actual samples that were used, those lawyers tried a case to that jury that they picked, certainly with whatever focus groups they did and whatever knowledge they had about that particular county. But they certainly struck jurors who they thought were problematic, who may not have been problematic for another lawyer, right? The same person could have found themselves on the jury for the same case with a different lawyer who got booted by someone else, so that's where like the trial lawyer aspect comes right into the fold, obviously in trial. When you see those actual jurors and determine, is that particular person going to be sympathetic to my client, harsh on my client? What's their direct background, their employment history? Maybe some family questions came up during jury production, whatever it might be. None of that can be sort of inserted into the prompt And so I was not really surprised by the fact of the huge discrepancy, and certainly with the fact that the actual verdicts exceeded the AI predicted potential verdicts, because I think that just shows the true understanding that those particular lawyers had, of their case and their client, and the actual jurors that they ended up with.
Also, how many times have we had a situation where you say to the AI after it gives you the response, "Are you sure?" And my apologies. I'm so sorry. I got it all wrong. So that's one way of vetting it. Is like, are you positive? Are you sure? I mean, where'd you get this from? And I've done this before, and 3 or 4 times. If I know the answer to the question, you ask it to give you the answer, it's clearly wrong, and then you have to kind of prompt it to finally get to the right answer. And the reason is that it's trained to get to an answer as quickly as possible. And even with the deep dives that it does, it takes time to develop that. And I think that goes back to what Spencer was saying at the beginning, is you have to refine the prompt and you have to refine your approach. But predicting what human beings are going to do, I think that's a ways off.
In my real estate one, it was pretty funny when I changed one piece of data, and it did actually come back and say, well, this changes everything. And I thought that I had never seen that happen before. And there was like a red siren, like a little emoji. And I thought that was pretty funny. I had never seen such a harsh correction by a change in a piece of data.
I will say that, one thing I take heart in is that there's so much data that for now AI can't use in all of its analysis. For example, there's a ton of proprietary data out there that just it doesn't have. There's a lot of data in our heads, as you're talking about, Miles, that it as yet does not yet have about values of cases and that kind of thing, and then interpreting emotions and circumstances. So thank God for at least a while it won't have that. And also the flip side is sort of what it does have is like, it's got a lot of human laziness in it too. It's reading the whole internet and everything. Like there's a lot of laziness out there, and a lot of wrong stuff. So, hopefully us humans have got a few more years in us.
Kicking it back to you, Spencer, I know that this is what I would describe as the qualitative discussion of the information that you've gathered from this evolution. It sounds like your team is also going to be doing some more work for a quantitative analysis and may have more information down the road. Can you forecast what our appetite of what that might look like and whether we might be seeing you again?
I hope so. We'll see. So one beautiful thing about law school trial advocacy is it is a good place for a lot of testing because, there are lots of repetitions, maybe not, thousands, but there's way more repetitions of these trials than there are real trials. Plus, every aspect of the trial is scored by, practicing attorneys, which have their limitations, but also like there's numerical, numbers that, numerical analysis that goes with people's thoughts about how good was that cross, how good was that closing, that kind of thing. So we've got all that data and who won each round. Did they win, all 3 judges, 2 out of 3 judges, that kind of thing. And we want to look at the amount of and the nature of the AI use as compared to who won in trials to see if there's any correlations that can be pulled from that. And frankly, I am quite curious. I would be fascinated to learn that there is no correlation, or that there is a I would think any of the answers would be interesting to me. But we do want to break that down. We've got some folks helping us, so I would love to report back should the opportunity arise.
I'm curious, and if you can't answer it, I understand. Do you believe that the team that won and had the most effective use of AI would have won if nobody was able to use AI? If you just removed that based on what and having seen them as trial lawyers and put on the case, do you think that was even a difference maker, or were they going to win anyways?
It's really interesting. Potentially would have made a difference because the team that they beat is a historical powerhouse in mock trial and didn't use AI very much. And, again, I don't know if that's good or bad. I'm not sure. But if you were to ask who's going to win that round, knowing nothing else in our community, you would not have picked the team that won. So maybe.
I think that's really interesting.
Any other questions for Spencer?
Want to be a defense lawyer?
You, sir, you're defending, plaintiffs' lawyers in part who, are
I'm
really needing your help. And so
I'm the only defense
God bless
lawyer
you.
guys like. I'm the only
Yeah.
defense lawyer that
Marshall's defending the wrongly accused.
bless him for it.
A final piece, and to the extent that anyone here has anything unrelated to what Spencer's been talking about, but we only get together about once a month or so. Anything cool, neat, fun that you've stumbled across in the last month that you feel our audience should get a snippet insight into?
I did have a pro per plaintiff use AI on me, and it's going to be interesting to see what the judge does, because we have obviously, and actually the hearing is tomorrow where this is going to come to light. It's in the relation to a motion for protective order, not a huge deal, but the pro per clearly used AI. All of the cases either don't exist or are mis-cited, and the propositions don't even remotely stand up. So I'm curious, because obviously as a lawyer, you know what's going to happen. You're going to get sanctioned. You're going to get referred to the state bar, whatever. But here you've got a pro per, and the judge doesn't necessarily have a ton of options for what he can do to this person. And so I'm really interested to see how it's going to impact the case as a whole. It's obviously not a big case, but I haven't seen yet, and I'm glad I get to see it firsthand, a judge deal with a pro per who is using AI. And I presume he may kick it over to us to seek some type of sanction, but we'll see. I think it's interesting because it's clearly being used by pro per plaintiffs all across the country and pro per defendants. And so I just think it's really interesting on my end to see how it's going to work out.
Well, and I thought that was it OpenAI that said that they're no longer going to let their systems give legal advice recently. I don't know where I read that, but that'll be an interesting development to see how that works. And the reality of it is there is a longer conversation to be had about access to justice for people who simply can't hire a lawyer, and how those systems are going to be used to operate within the court system, and whether or not any of the free legal clinics that are out there are going to be able to tell people how to use AI to protect themselves or to advance their cases in court. But that's obviously a much longer conversation.
I will say that in a connection between mock trial and our practices, one of my friends who's a trial lawyer about my vintage in South Carolina runs University of South Carolina's very good trial competition team. He had a trial against a pro per plaintiff who was, very clearly using, I don't know what platform it was, to try the case. And I don't think it was pretty, but he got through his case in chief, and he had left out some, very important, like jurisdictional or other, element in the case, and got non-suited at that point. But like, that is far down the road right there, that, to get that far. So wild story.
Yeah.
We'll look forward to getting an update on that, Marshall. Next time we meet.
For sure.
Well, anything else that anyone use, Spencer, particularly since you're a guest, feel that we should cover?
I can only give my 2 cents to say that it scares me, but it also excites me. And of late, I've been feeling a little bit more optimistic. It is a powerful tool that is a tool, in much like the spreadsheet was 40 years ago, except for 100 times or 1,000 times more powerful. And God bless humanity. And I hope we're still necessary for a very long time into the future, despite our helpful tools like AI.
From your lips to ChatGPT's ears. Well, thank you, Spencer, for joining us. And Marshall, Shahrad, it's always a pleasure. I enjoy these conversations. It helps keep my mind stimulated on the AI front. So,
love it.
Thanks for having me, guys.
Yeah.
Really appreciate it.
For all you listening out there, thanks for listening. If you have any questions, comments, feedback on how you've been using AI or any trends that you've seen, please email us at podcast@coopers.law. For all of you doing justice out there, happy hunting.